Good afternoon and welcome to our webinar on the revised COMESA Competition and Consumer Regulations now in force. My name is Lizelle Bluchnoot and I'm an executive in E&S's Competition Antitrust Department. It's my honor to introduce our discussants in today's webinar, Dr. Willard Mwemba and Jocelyn Katz. Dr. Willard Mwemba needs no introduction. He's the Chief Executive Officer of the newly rebranded COMESA Competition and Consumer Commission. He is a member of the advisory board of UNCTAD's Competition Training Center for Middle East and Africa. Willard is also currently a lecturer at the University of Cape Town, where he holds a PhD in competition law. Willard is a scholar and a thinker. He has written extensively on the subject of competition law. Above all, however, Willard is a respected regulator with a practical mindset, always looking for solutions to complex problems. He continues to play a key role in the development of the competition landscape on the continent and beyond. Jocelyn Katz is the highly regarded global head of E&S's competition antitrust practice, adored by her clients, respected by her counterparts and peers, and appreciated by regulators. She is the undisputed queen of multi-jurisdictional merger filings on the African continent, having filed many a complex multi-J and having had to juggle parallel processes with numerous regulatory authorities across the continent. She leads an elite and Chambers Band 1 multidisciplinary competition practice and is herself rated by Chambers, GCR, Legal 500, Best Lawyers, Who's Who Legal, etc. Always one step ahead of the commercial, regulatory, and political changes and challenges that face clients, she is appreciated for her strategic, commercial, and above all, innovative and problem-solving skills. She adds value to every deal. In addition to her thriving mergers practice, Jocelyn is also involved in market inquiries, cartel investigations, and abuse of dominance investigations across a broad range of industries. Willard and Jocelyn, thank you for making the time to speak with us. Willard, we're sure that the past few weeks must have been extraordinarily busy for you and your team. The approval of the 2025 regulations and rules on 4 December 2025 marked a watershed moment for competition law in the common market, and we have no doubt that your inbox has been overflowing with queries ever since. In this webinar, we want to explore how the new framework will work in practice. We want to air the questions businesses and advisors are asking, and we want to debate the answers they need. Whilst we will focus primarily on merger control, we will also touch on conduct matters and what lies ahead for enforcement more broadly. Before we get started, however, I would be remiss not to acknowledge the Commission's rebranding to the COMESA Competition and Consumer Commission, or QuadC, as it's popularly known. Consumer protection has, of course, always been part of the then CCC's mandate, but the rebrand makes the dual mandate explicit. Perhaps a signal that consumer matters will command greater attention going forward. We'll watch this space. To our participants, thank you for joining and for sending through your questions in advance. We are confident that most of these will be answered during the webinar. However, if you have any additional questions, please post them in the Q&A box. We hope to have sufficient time to address those questions as well. Now, over to you, Jocelyn.
Thanks, Lizelle, and thank you for all of those unexpected and lovely words. Hi, Willard. Lovely to see you, and a warm welcome from me to all of you, and thank you for joining us. I'm super excited to get to all of these questions. As Lizelle mentioned, we're going to start with mergers, but perhaps let's start with the big picture. What has motivated the revamping of the COMESA Commission, COMESA Competition and Consumer Regulations? Oh, you're on mute.
My apologies. So I'm saying thank you so much, Jos, and thank you for having me. Thank you for Lizelle's kind words. And at least I know your other name, the Queen of Antitrust Multi-Jurisdictional Filings. Now, get into business, Jos. What motivated us to review the regulations? The answer is very simple, Jos. The law is a living organism. It grows. It shouldn't be stagnant. Otherwise, when it is stagnant, it loses purpose. It doesn't address emerging realities and the like. So the original COMESA competition regulations were promulgated in 2004. Even if enforcement started close to 10 years later. The law was in place and had been approved in 2004. And it only got amended or repealed and replaced in 2025. So that is, if I count my math well, that should be about 21 years later. And you agree with me, Jos, that a lot of things has changed on the competition landscape in 21 years. So that law had become inadequate to address certain issues. The second one was, and I know lawyers may not like this and your clients, but yeah, the second one was we observed the law nature or amounts, quantum of our fines. They were very, very low. And it became very clear to us that, number one, they were not a deterrent to would-be offenders. Number two, in fact, they did not deter repeat offenders or recidivists, as you may call them. So we also had to think twice and say we need to amend this law to have meaningful fines, meaningful penalties that can address competition issues in the market. And lastly, obviously, among so many other issues, but just the main ones. Lastly, the emerging issues, environmental issues, digital market issues, AI issues, which were completely absent in the previous law, but which are some of the things that we are facing and grappling with, not just competition authorities, but everyone else on the planet. So we thought to remain relevant and address problems and challenges of modern times, we needed to amend our law and put provisions that would address these issues.
Thanks, Willard. And you certainly have done that. And we are going to get to some of those items a little later on. But perhaps to stick with the mergers for now, COMESA, the original sort of concept of COMESA was this is a one-stop shop.
Right.
And, as many in our audience will know, the reality of that is not always played out that way. Over the years, there have been some jurisdictions where, we've been called on to make a filing, even though we filed with COMESA. So, for example, currently in Egypt, the Egyptian Competition Authority, the ECA, has come out publicly to say that they do not recognize COMESA as a one-stop shop, that they require parallel filing where the Egyptian thresholds are met. Now, the new regulations, put this in black and white. The Commission has exclusive jurisdiction on mergers which meet the prescribed thresholds, that it shall be contrary to the spirit of these regulations and the treaty for member states to call for the notification of mergers referred to in these regulations at national level. So does this now settle the matter once and for all? Is exclusivity now recognized and accepted by all member states, do you think?
It's a very interesting question, $1 million question, Jos, and I'll dwell a little bit on this. I know we have quite a lot to cover, but I'll try to dwell a little bit on this because I think it's a very important thing we need to address and for your clients and indeed the audience to appreciate. First of all, Jos, I would love to clarify that, in fact, over the past years, unless you say maybe very recently, over the past years, in fact, COMESA has entirely functioned as a one-stop shop, a major review jurisdiction. I think the problem you recall is when we began our operations in 2013, Kenya had some issues. But if you remember, the issues with Kenya did not go for long. And Kenya, I think their argument then was that COMESA just stormed from nowhere. They were not ready. We did not sit down with them on how this was going to spell out, how this was going to be rolled out. So for them, they were calling for certainty, guidelines that will assist in understanding which transactions comes to COMESA and those that go to CAK. So if you recall very well, it didn't take long before we addressed that matter with CAK. It was a little nasty at the beginning, yes, but we addressed it not so long after that. And when we addressed the issue with CAK for quite a long time, all COMESA member states, I think, unless or otherwise, I'm not aware of that, all COMESA member states, including Egypt, were respecting the jurisdiction of the commission and the one-stop principle. Now, coming to Egypt, you will recall that Egypt did not have a major control law before. And I think at the time we were doing all these things with Kenya, putting across the guidelines and everything, Egypt still did not have a competition, a major control provisions in their competition law. Once they had those provisions in their competition law, I heard from the market, from the lawyers, that Egyptians are asking us to notify. And at that point, I made it very clear to the lawyers that in as far as the CCCC then, which is a Quad C now, is concerned, Egypt is part of the one-stop shop, and I wrote to Egypt. I wrote to the Egyptian Competition Authority, to the chairperson, Dr. Momtaz, and I think his response to me was that they've never challenged, neither have they disregarded the one-stop shop principle. So that's the official position that I have currently from Egypt, because I've even sent letters officially signed by myself, responded by the chairperson of the Egyptian Competition Authority, who happens to sit on our previous CID committee responsible for initial determinations, that committee that makes determinations on the filings you make before us. So that is the official position from Egypt. However, again, I think we should be very transparent so that we settle this matter once and for all. However, I've heard that there have been officials from the ECA, not the chairperson himself, or not at that very high senior position, but I've heard that there have been officials from ECA who have actually said that and insisted on some public fora that notifications to Egypt will be required. What I'll do now that we have these new regulations, Jos, once again write to the Egyptian Competition Authority with evidence. For example, there are some lawyers who've given me notifications that have also been submitted to the ECA, and then we'll get the response from there. However, as you said, the regulations are very clear now. They say all member states should respect the one-stop shop. The jurisdiction is exclusive with the Commission. But we can't force countries, Jos. Countries are sovereign. They've got the free will to comply with what they want. The only thing is that they should also know that there's a principle of pacta sunt servanda. If you have obligations, you comply with those obligations in good faith. So I'm not talking about Egypt now. I'm just talking about this in general. If there's any member state that does not wish to comply with the regulations, they need to make it very clear to us, which we've not gotten to date from any of the 21 member states. They need to make it very clear to us so that we communicate to you, the lawyers, that this is the position. And then there are other consequences for such a member state as is provided for in any interaction of such nature. So, for example, they may not benefit from certain things from the Commission, technical assistance, capacity building, major filing fees, recruitment of staff from that member state into the Commission. So all those are the safeguards that are there, that those who do not comply with this, because if you're a member of the club, you should comply with the rules of that club. Otherwise, if others are subjected to the different set of rules and the others another set of rules, the club ultimately collapses. So those who do not comply, there are also safeguards that are put in place, so they do not participate in anything to do with that project.
Thanks. That's helpful. I suppose, I mean, I can confirm that I have clients who have been called upon to make a filing in circumstances where they've made the filing with COMESA and then they've been called on to file in Egypt. What advice would you have for those clients going forward now? You know, how would you advise a company who receives such a demand from the ECA in light of these new regulations, considering that they could potentially face a penalty if they don't comply? You know, what is sort of the process for them to follow?
To start with, Jos, I really sympathize and feel so bad for your clients. I sympathize and feel so bad for the market, because uncertainty is so terrible in this kind of business. So, but my advice, first of all, I would state what the law is. My advice would be that as long as we do not have a clear position from any of the member states stating that they are not complying with that, it means they are bound. because they only are not bound if they choose not to be part of this, and then other processes follow for them to not be part of this. So it means they are bound. So legally, your clients may wish not to notify. And there's lots of case law by the COMESA Court of Justice, especially the Republic of Mauritius has been on the spotlight regarding similar issues on trade issues, where COMESA Court of Justice has made it very clear that if you are part of this club, you will comply with all these regulations. And Mauritius has reversed some of the decisions it made in non-compliance to the treaty. Those decisions basically would apply in this situation. Now, that's why I said I sympathize with your clients, because majors are also time sensitive, the value of the major itself, this market value and what. So when there are all these uncertainties, it may have an effect on the transaction. So while your clients may be on sound legal grounds to say we are only notifying with COMESA because we don't have an official position, the fact that there is that risk of them getting to court to argue that does not make sense, and most clients would not want that, which I really sympathize, because then that's a problem of us, the regulators, the quadrocy, and the national competition authorities. But under the circumstances, Jos, what I would advise is that once you are making a filing, or if you are asked to file before the ECA or any national competition authority, as the case may be, you may actually write to the ECA telling them the position of the COMESA law, then copying us, so that if they respond to yourselves, whatever response they tell you will also be in copy. I think that then puts everything transparent, and we see how we forge ahead. But I should say it's a very unfortunate situation if indeed that's what is happening on the ground. And I can assure the clients, your clients and the market, that we'll do everything possible to address this anywhere where it is occurring.
Thanks, Willard. That is indeed a comfort. And I suppose maybe my next topic maybe is the answer, and that is, when Egypt brought in their new regulations, they were suspensory in nature, and maybe there was that disconnect between COMESA, which was not suspensory but is now. So maybe that becomes
you've actually hit the nail on the head. When I spoke to the chairperson of the Egyptian Competition Authority at that point, he did not say they are not complying with the one-stop shop, but he did tell me that Egypt had concerns that since COMESA is non-suspensory, there may be a transaction that affects Egypt, and then it passes through COMESA, and then concerns are later found in Egypt. So indeed, he did genuinely, and I think it's a legitimate concern at that point, that they were looking forward to the day when COMESA regime would also be suspensory. So let's see how we move ahead now that the COMESA regime is suspensory. And then, Jos, I don't know if what I'm saying here is now right, or I'm revealing too much. The chairperson had also told me that, in fact, it was not the ECA that was asking you, the lawyers, to notify. It was the lawyers who were advising their clients to notify. And once the ECA received the notification, it was not their responsibility to start checking on whether it complies with them. They just had to look at it because it had been notified. So for me, that is the position that I officially have, and that's the position I would be giving here. But I understand also your concerns and that it could be happening on the market, maybe because of some disconnect, as you've said. We will sit down and put this to a closure. If indeed Egypt is not part of the one-stop shop, we'll make it very clear to the market very soon. If they are, we'll again come back and make it very clear to the market. With the rest of the 20 member states, we've never had any such concern from the lawyers. I don't think even from ENS itself.
Yeah. No, I think that's right. And I think for many people on this call, I think that will be hugely helpful, what you've just said. I think that's very, very comforting guidance. So to move on to this suspensory regime for about a decade, I think it was.
Yeah.
We've had a non-suspensory...
A decade plus 2 years.
Yeah, exactly. Okay, 12 years. Meaning parties could close the deal while it was being considered by the COMESA Commission. That is now over. Under the new rules, parties must now wait for the Commission's clearance. For parties, for advisors and firms engaging in merger activities, this kind of elevates COMESA in the considerations of timing and, and how you build that into your timetable. What prompted this change to sort of a suspensory regime, and how would you sell the benefits and necessity of suspension to the business community, who are obviously always concerned about, as you mentioned, certainty, but timing and execution risk, under this new regime?
No, to start with, I think the non-suspensory regime had an advantage to the merging parties. As I said earlier, mergers are very time sensitive. The value of mergers as shares and things like that can collapse or gain value depending on the procedures of the regulatory procedures. So we did appreciate that, and at least on that aspect, the non-suspensory review had an advantage to the clients, in that, to your clients, the parties in our case, in that they did not have to wait for the commission's decision. As long as they notified, they could go ahead and implement the merger. That was good, no time wasted. However, the non-suspensory regime had also a serious disadvantage, I think, to both the commission and the parties. To the parties is that while you could notify that you could implement the transaction and go ahead quickly, you finalize all your procedures, the risk still remained at your back. And you are very conscious, not knowing what the commission would say before. And I think it explains that even when we had the non-suspensory regime for 12 years, we only had 2, 3 at most transactions that were implemented before the decision of the commission. So in practice, parties were still very mindful that they needed to wait for the decision of the commission, I think because of that risk. 12 years, 2, 3 at most, if I can recall very well, that were implemented before the decision of the commission. So that was a risk on the parties, but it was also terribly unsettling and concerning for us, in that we were thinking, what would the situation be where the merger has already been approved and we say this merger is anti-competitive? We were mindful not just of our part or our input into that merger. Remember, Jos, and I always tell competition authorities that don't be too big-headed. You're only a little dot in this entire and broad scheme of things. There are so many other regulators. There are so many other private sector stakeholders, banks, and what. So there's so many things that these merging parties, these guys, have to comply with. We are not the only ones. Our fear was, in an event we said now this merger is anti-competitive and it has been implemented, the recourse is to unwind it. What would have been the repercussions broader than just competition regulation? Okay, so even for the commission, that was very worrying, and we did pray and hope that that would never happen. So to avoid and move away from all those uncertainties for the parties themselves and the commission, we thought it wise that a suspensory regime would address that. So that once the decision is given, the parties know that's it, we are done with COMESA. Once the notification is made for COMESA, we know that there is no risk that we'll have to force the unwinding of this transaction, because it won't be implemented before we look at it. Basically, that is what motivated us, Jos.
Thanks, Willard. I mean, I understand both aspects of what you're saying. I think I might know of a little more than 2 or 3 matters deals that might have closed prior to receiving COMESA approval. And I think maybe on that, the risk really is more the party's risk than a risk for the regulator. And I think that in matters where the risk is low, and where there is no issues and very, very low prospects of any kind of prohibition, in those matters.
Is it me here?
Sorry, have I lost you, Willard? There you are.
I lost you for just a few seconds, but I think I got what you're saying.
Okay.
I was saying
that sorry, can you hear me?
Okay. We're good now.
Can you hear me now? I think we're back.
Yeah.
That in matters where there isn't any material overlap.
We're back. But I got you, but you can go ahead.
So I was simply saying in matters where there's no material overlap or likely, not to be any material issues, there's very low risk in parties closing those transactions. It's really only in significant matters where there are significant overlaps or issues arising out of the deal where there's a real risk. So in a way, the vast majority of cases are now caught under the suspensory regime when those are the ones that were not really at risk. It's really just those at the margin that really created that risk. I don't know if you have any thoughts on that. Be that as, many regimes are suspensory, but is it enough of a risk to have made that change?
No. I hear you, and I think the Commission was cognizant of that, and that's why I started by saying the suspensory, non-suspensory regime, in fact, had some greater benefits to the parties. However, I think it was a balancing act, Jos. What is good, certainty or uncertainty? So we thought certainty was much better. Then we looked at the low risk that you have talked about, and you are right, 100% correct, by the way. The question how did we address that? We said, what if we put certain provisions, even under the suspensory regime, we put provisions that may attempt to address that issue of timing. And that's why if you've seen our new law, it talks about an expedite. Is it the new law? No. I'm thinking very fast. I'm now disclosing what has not yet come to the market. Currently, we'll be issuing, I think, in the next 2 weeks. To address that, we are now coming up with an expedited review period. Okay, maybe if we have time, we'll talk about that later. We are coming up with an expedited review period. So it's still suspensory, but where such a situation arises, such factors are there. There is no overlap. There are no likely competition concerns. The merger is very competition neutral. The parties at filing of this transaction may, in their accompanying letter, raise all those things and make an appeal for an expedited review. It is something we are working on now. I think the board will be sitting next week. If it is approved, we'll have it the other week. We are thinking just that would also coming to try to balance that risk of the timing that you're talking about for non-complicated transactions.
So that's excellent news, and I'm sure the audience is delighted to have heard it here first. I was just about to ask you about the timeframes not having changed. I suppose the statutory timeframes haven't changed. But what you're saying is that you're going to introduce an expedited or fast track type of process that will enable those transactions that don't require the full 120 calendar days, if it meets certain criteria. Those criteria, from what I'm understanding, are going to be published for parties to see.
That's correct. We'll be publishing that, yes.
Fantastic.
So, yeah.
And a question that no doubt the audience will be interested to know is whether there'll be a fee attached to this expedited process, as there are in some jurisdictions.
Exactly. And these days I'm very scared to talk about fees because what is happening now, Jos, for me, it's like I'm reliving what was happening in 2013 when we just commenced our operation. So $500,000 and everything like that. But look, I remember
that.
Exactly. To give you the answer, yes, we are proposing a fee to that, because what would happen in the expedited review is that this will be an individual transaction filed by Jos, and Jos has told the Commission that I do not see any of these. This transaction does not raise any competition issues, no overlaps. The parties do not have significant market shares in any case. All those factors that you'll see later when we publish. So Jos would be making that application and she'll be saying, I need an expedited review. It means if we accept that this needs an expedited review, we'll be taking that transaction, Jocelyn's transaction, to the panel that makes determinations on transaction, just to sit for that one. Why? Because also it would be administratively expensive for the Commission if they will have to call panel sittings every now and then where we have such. Okay, because those panels, they sit only when there's enough caseload, then they come and sit to review. But in this case, if we have to satisfy your requirement or your need or your request that I need this one to be reviewed quickly, it means we are giving it attention and sending it to the panel in isolation to the other cases. So the cost of convening that panel clearly will have to be borne by the parties. So we will attach a fee there. It is somewhere in the draft, but I'll not mention it today until it is approved.
That's fine. I think that's understood. If a special meeting has to be called to consider a particular matter, and I think it's accepted that there are costs associated with that. In the same vein, I wanted to talk about derogations. So there's new Regulation 42 allows parties to seek a derogation to proceed before clearance. So the practice note says that there's a practice note that you issued earlier this year.
1 of 2026, yes.
Yes, that it will be granted sparingly and only in exceptional circumstances and largely confined to public bids and securities deals. So obviously we know that your regime is brand new and just commencing, but could you perhaps talk us through that? Would there be room for derogations beyond the public bid scenario, for example, where there's, sort of the kinds that we've talked about before, if there's genuine financing or distress pressures? What would a compelling case look like, and what safeguards would you expect parties to offer to qualify for the derogation?
It's a very good observation as well. And Joss, are you getting me? Yeah.
Yes. Yeah.
You're getting me? Okay. Yeah, it's a very good question. And first of all, I like it that you are already mastering our exact provisions. I like it when you say Regulation 42. Even as in the Quad C, we are still struggling to find which regulations. So I like that. And then I also like your observation when you say these are brand new. So we are really, and I'll be very honest with you that we are equally learning, just like yourselves. So we are very cautious. We know that at some point in the future, Joss, we actually are empowered by that particular provision who again come up with certain types of measures and under what circumstances can derogations be given. Currently, we have no clue of what measures may benefit from that, except for what is provided in the law itself, the public bids and trading in securities that you saw in the regulations. So currently, as things stand, we only restrict ourselves to trading in securities and public bids. Those derogations would be considered, but that is not to say the door is closed. Yourselves, remember, just one thing that the Quadro C prides itself with is that we are so open, we are so receptive to listening to what the markets say. So yourselves, the lawyers in the common market, and South Africa, which is not a common market, and I should commend South African lawyers, let me take this opportunity to say that you assisted us a lot in shaping approach of not just major control, but competition regulation under the old regulations. We are looking forward. We are looking up to you again to assist us. So as we begin to interact on some of these transactions, circumstances and situations will be getting more clear as to what transactions, in fact, should not waste the commission's time, as long as they've been notified. So to answer your question, just currently, no. We are only restricting ourselves to what the regulations are saying, the public bids. Why? Because we don't have any experience yet under these regulations, but we are not closing the door as we interact more with you, and as you convince us more as to why your transaction, in fact, should benefit from the derogation. We will come up with, again, a notice that would consider derogations in other situations.
Thanks, Willard. Once again, very, very helpful. I mean, I think if I think about my practice and the kinds of things that we would want to make submissions on, it would definitely occur to me that in distressed sales or businesses under business rescue or in difficulty, financial distress are primed for that kind of thing. They're often incredibly time constrained. Jobs are at risk. Are about to close. It's those kinds of things that I suspect we'll be making submissions on, should that arise.
No, that's very correct, Jos. And I think the comfort the lawyers should have and your clients are that the mere fact that the commission put that provision means it was aware of situations that may arise. Except currently doesn't know which exact situations. So that provision is still very helpful, and indeed it will make us evolve to where we want to be to include those other derogations.
Thank you. So I wanted to touch very briefly on the digital mergers, and I say briefly, we had many questions on this from the audience. We may need to have part two, just to deal with the digital mergers. But maybe I'll ask you a couple of questions and then we'll move on to the next topic to fit everything in. So the regulations introduce new thresholds on digital mergers. Based on global transaction value, which means that low revenue transactions that have high data or innovation value are now captured. So have you experienced any change in the profile or volume? I know it's early days, but yet have you seen a change in the volume and type of notifications or queries that you're getting? You have a very lean staff. Is this having an impact on, sort of how quickly you can get through the merger load? And can we expect guidelines to help parties navigate the approach on digital mergers, such as sort of the local nexus, metrics that will be considered to determine the impact on competition or innovation? I'll stop there. Maybe there's a couple of follow-on questions, but maybe I'll stop there.
No, thanks. Again, thanks, Jos. It's early times. Our new law is only less than a month in practice, because immediately it was approved, the commission went on break. So we only started enforcing it in reality after the 9th of January. So it's quite very new, very new. But I'll tell you that we've already received cases under those regulations. In fact, moving out of measures, just for your interest, we've already received a complaint against Meta on the basis of our new regulations with regard to digital markets. Not a major, but because our new regulations are quite expansive on digital markets other than just majors. But for majors, no. And now I regret I missed the Activision Microsoft transaction, the Google Fitbit transaction. If it happened, then this one would have been captured. Now,
so we were acting for Microsoft, so I'm gonna just say that it was well timed.
You were very lucky. Now, to come to your questions, we have not yet seen a change in volumes. And again, as I've said, it's because the law is very new. Maybe by the end of the quarter, we may give a better answer to that. But then secondly, you are right. Again, these are new frontiers, these are new territory. There's a lot of uncertainty. The commission itself is also learning. So we will be issuing guidelines in due course on how we will approach mergers in the digital sector. So that is number one. Then number two, I think your concern is that we are likely to be inundated by a lot of mergers. Before the guidelines, I think you are correct. Just like we did in 2013, before the guidelines will be very strict. We'll simply be saying if the 250 million transaction value threshold is met, the transaction is notifiable. So in the interim, before the guidelines, yes, we are likely to have so many. But once the guidelines are issued, it will also have some exceptions. It will not be every transaction that meets the 250 million. The nexus that you're talking about, the number of users that we have regarding those platforms that are merging, the importance of the platform to our consumers in the common market. So we'll have a number of factors. Some of them may not even be important, but the transaction value is met, but they may not be something that is of very significant importance given the level of our market and economic development currently. So we'll do that. But then the last one, you spoke about our lean staff. I agree. Our staff is quite lean, but I can also assure you that will not affect the turnaround times. The staff is lean, but very efficient. Jos and Lizelle, in fact, I have a bond to chew with you. So today I publicly say that. One of my staff was Sandhya Bullock, who is with you now, right? So
She is, and she's wonderful. I'm sorry.
so what I'm trying to assure you is that my staff, they may be lean, but they are very efficient. And I'm sure, I hope Sandhya is demonstrating that efficiency with you so that she carries that as our ambassador. But we have also
She absolutely is. I can confirm.
Great, nice to hear that. But we have also increased the numbers. We from 3 or 4 at some point. Now we have 7 people looking at mergers and acquisitions. So it is not as good and where we want to be, but it is definitely better than 3 or 4 if you are moving to 7. So that is what I would say on that. But regardless, you can be assured that these are people who work round the clock, who are so dedicated, and they will not give an excuse of we are few in number, so this transaction will go on and on and on. No, absolutely not.
So I can absolutely confirm on 2 fronts that is my experience. I receive emails from your team at all hours of the day and night and weekends. I absolutely have seen that, and I can confirm it on the second front, based on Sandhya's absolute excellence and her approach to work. So thanks, Willard. That is assuring for us, and I wish you and the team lots of luck with the increased volumes. But no doubt you'll be up to the task. I want to move on to public interest considerations, which is a significant change in the substantive test, the introduction of what we in South Africa would say are sort of traditional public interest grounds, but also environment and sustainability, which we'll come to in a moment. Your regulations absolutely clarify that it's secondary to the competition assessment, which is great. In South Africa, as you know, it carries sort of equal weight. Yeah. And this has produced somewhat headline-grabbing outcomes that have been at times controversial and surprised the market somewhat. I know that you and the South African competition community have had lots of close engagements. Which jurisdictions is the Commission likely to look to for guidance when it comes to weighing the public interest factors, given that there's a difference in the approach between what your legislation is saying and the South African approach? How do you see that sort of playing out?
I think my answer would be very controversial, Joss, very controversial and maybe even a little unconventional. I think the immediate answer is none. I'm sure that shows you. None. And the reason is that, look, maybe it's because of the unique situation in which we are. When we come to our member states, what they may consider as significant public interest at national level may be different from what we consider as significant public interest at common market level. So it's very unlikely that we'll be making reference to Zambia, Kenya, Malawi. These are countries I know that have serious public interest considerations in their approaches as well. Okay, for example, Zambia, they always talk about the issue of which I left, by the way. I'm a culprit of that, but then I regretted that. Every major, even before you look at it, and I hope the Zambians are not listening to kill me, but every major, when you look at it, it says the major is approved on conditions that all the supply contracts and what that were entered into by them should continue. But sometimes the continuous or continuation does not make sense in certain circumstances, so it should be contextualized. It should not be a given. So, for example, we may not adopt that Zambian approach and we may not be looking up to them. South Africa, we find the approach in South Africa quite very different from how we understand public interest. So public interest will be as the Quadro C now, I'm still saying Triple C, as the Quadro C views it in regards to the entire common market or a substantial part of it. So just if it is public interest that is only affecting Zimbabwe and none of the other COMESA member states, it is highly unlikely that the commission, the Quadro C, will be troubling your transaction that, look, there are these We may take that into account. We may discuss with you, obviously, the best way is to try to resolve the issue amicably. But if worse comes to worse, there is no way we would say this pro-competitive measure that you submitted, Jos, it has serious issues in Zambia, but not the rest of the common market. And the issues are not competition. The issues are public interest. So we stop that transaction. No. So our approach will be very different. And I think we'll be having our own bespoke, own designed public interest approach that is different from what others look at. The factors may be similar, but how we weigh those factors, how we project those factors, how those factors influence our decisions will be totally different from everyone else that I know.
We absolutely, I mean, I take what you're saying, and I think that that's the right approach, that it's a market-wide impact as opposed to an impact on a member state. I think you have your work cut out for you in terms of how you're going to do this analysis, but we look forward to walking that road with you, I think, and bring all of the experience that we've had, you know, on the public interest issues, not just in South Africa, but in all of the jurisdictions that you've mentioned. You know, we've been navigating this for some time. It's complex.
Yeah. It is.
But
it is.
I think it's It is.
And even from us, Jos, I mean, I appreciate that we're dealing with member states. That's why I said if Zimbabwe raises that issue, we will not dismiss Zimbabwe. We will try to address it with you and see if it is something that can be addressed, because obviously in this business, especially major control, the best outcome is that one that has been amicably resolved.
Absolutely.
But in the worst case scenario, the commission will not be like other authorities, which will say, then this pro-competitive measure will be rejected because of a public interest. So maybe to clarify and to make it very simple, JOS will be considering public interest, but we are very unlikely to reject a pro-competitive measure because it has public interest concerns. We are unlikely. We may, but we are unlikely. And where we will do that, I think it will be clear for the whole world to say that this is terrible to public interest. The vice versa is equally true. We may approve an anti-competitive measure if it demonstrates serious public interest. But we are also unlikely to approve that anti-competitive measure because of the benefits that you are telling us. Only where it will be very clear to the rest of the world that indeed now we will never use nuclear physics to generate energy. We will never use coal to generate energy. We will simply use wind and sun, and all these things will be phased out tomorrow. This is the public interest the measure is bringing. Those circumstances where the whole world can see that they are there, then we'll say, well, this is anti-competitive. This benefit is too good to ignore. So I think I've portrayed our approach somehow, how we proceed on this.
No, I think that's understood. And thanks. You've actually touched on what I want to move to next, and that is just the particular public interest ground, which is new, right? And that is environmental and sustainability factors. That's
correct.
Fairly unique. This is absolutely frontier territory. Very few competition authorities have meaningfully integrated environmental considerations into their enforcement practice. What has prompted the inclusion of environmental and sustainability considerations to be considered by the Commission?
Good question. And I think, as you say, it's frontier territory indeed. And maybe others would say, did we go astray? That we are now in some territory that we shouldn't be having, we shouldn't be in. Now, Jos, I think the Commission realized in recent times that the world is so troubled, geopolitical tensions, wars, and then climate change as one of the existential threats that the planet is facing today. And we said, is it possible that the competition law, especially for our continent, Jos, for countries that are rich, countries that are wealthy, death is death, tragedy is tragedy, but the way they come out of that tragedy is much easier than us because of the resources that they have. Okay? For us, because of the nature of our economy is not so much resource. When there's this tragedy, it takes low. So the impact, in other words, just is felt more here. And
Of
we
big
said,
environmental disasters. Yeah.
environmental disaster. And we said, what role can we play? Even if it's a small role, what role can we play to ensure that we at least ameliorate the impact of climate change? And we looked at the public interest that we're talking about and said, hallelujah, this can be part of public interest. If we have a transaction, okay, Joseph, if we have a transaction that will result in a reduction, significant reduction of greenhouse emissions, why then not look at that as one factor that should support the looking at that transaction favorably? If we have a transaction that in fact would be vice versa, and that will reverse all those gains, why shouldn't we take that into account? If we have transactions that make it very difficult for others to enter in the green solution space because of domination, why shouldn't we say we are concerned in this market where you operate, that there are other companies with green solutions, but they may find it very difficult to operate in here because of the concerns that we have with your merger. Okay, we thought we should be looking at that. We went beyond that, Joss, even on agreements, not just mergers, restrictive business practices, and said we should also look at this. If those restrictive business practices make it very difficult for others to operate in the space where they can provide solutions to the ongoing climate concerns, we should actually look at those and say, oh no, this will not happen. But the good question may be, what if we had an agreement that is cartel-like in nature, and it is bringing these benefits? That one, maybe the answer would be no, because the law, again, I would have loved to consider it myself anyway, but the law is very clear that it says cartel conduct is per se. So there, they can't benefit. But maybe when we go to suspension in times of crisis, and we'll see how that can work out. But ideally, for agreements, even if they are having environmental benefits, as long as that agreement is cartel-like in nature, that one will not benefit. Sorry.
Thank you. So will the Commission be issuing guidelines, specific guidance on how this is assessed? And are there particular sectors that you would expect this to sort of crop up? I mean, energy is the obvious one, I suppose, manufacturing, mining, things like that. But has the Commission, I mean, once again, early days, but have you given any thought to that?
Yes, we will definitely issue guidelines for certainty to the market, but clearly we will be looking more at those industries concerned with extraction. So mining, fossil fuels, agriculture, those ones where we think they've contributed so much to environmental damage, exploration, mining, fossils, agric. But we'll issue guidelines. So again, it will not be each and every sector where we'll be so much focused on when we're looking at environmental issues. It will be those factors that we think consideration on environmental issues matter. The examples I've given you would definitely appear: mining, fossil fuels, agric, and things like that.
Thank you. I'd like to move on to regional cooperation. I will confess that this is the question I've been most interested in.
Yeah, I know where you're going.
You know where I'm going. It's two parts. We were originally going to ask you just one part, but then we had a question from our audience, so it's going to be in two parts. But one of the talking points when the EAC, that the East Africa Community Competition Authority, became operational was the large number of overlapping jurisdictions and the potential overlap of the two authorities. So we understand that you are in close communications with the EACC. Yeah. You're trying to resolve this. The 25 regulations through Regulation 75 envisage the possibility for engagement with regional authorities to determine the best placed agency. have there been any developments? This is our original question, and I'll ask the part two. But have there been any developments, and are you sort of demarcating jurisdictions and practical criteria that will guide the allocation of merger cases? What is the status of that? And I'm going to ask you the part two, because you may want to answer it all together, and that is the Safaricom merger was recently filed at both the Quad C and the EACCA. The question from our audience was the filing submitted to each of these institutions, was the full filing, submitted to each of these institutions, i.e. will both institutions review the effect of the merger on the overlapping countries? Before you answer, I must make full disclosure that ENS was involved in these filings. So as we understand it, the issue hasn't yet been resolved. So we did submit a full filing to each authority. We are, as I said, waiting with bated breath to hear how Quad C and EACCA intend to deal with this transaction. So maybe if you could answer it in particular in relation to the transaction as per our audience members' question, but also the sort of general status of things, if you could address that.
Well, thanks, Joss. And I that's why I joked with you. I said, I know where you're going, and I know where you are going will end up giving you some comfort. Why I knew where you are going is that when the transaction was notified to us, that Safaricom, Vodafone, you also notified the EAC, and the EAC immediately reached out to us. Okay. So they immediately reached out to us. I said, we know you have this transaction there. It has also come to us. How can we sit down and work together to ensure that the outcome that we have is not something that is confusing to the parties? Okay, so that is not where we want to end. We want to have better news than that, but it is still a step in the right direction. That the two institutions, the regional institutions, in fact, are talking and realizing that there is danger that there may be divergent outcomes from the assessment. So we should sit down and look at this transaction. Secondly, just as you said, and I'm liking you going particularly to our regulations, the regulation number. I think you are challenging.
Yes.
You are really challenging myself, and I think my staff. We need to do better, because for us, we are still flipping which one says that? Okay, so I like that. Okay, that 75 is good news also, because it means when the commission was coming up with the law, it had this in mind. It knew that some of these things may happen. So it already put a provision that we will use to address the problem. Unlike before, where we simply say, this is what my law says. I cannot do anything because my law does not allow. So that's why Quad C put that. Thirdly, Quad C has been in discussions with the EAC, which resulted or led to the conclusion of an MOU that was signed, I think last year in June 2025, if I'm not mistaken. And in that MOU, there is also a provision that is very clear that IACA and Quad C, Triple C then, will have to sit down and resolve this issue of double notification. And fourthly, which should give you enough comfort, the IACA Council is very much aware and in fact has given a directive. So at that high policy level, that Quad C and IACA should in fact resolve the double notification issue. For us, that gives us impetus, because then there is support from the policy levels. It's just a matter of time to put in the criteria. And the Quad C has already put in a draft, which is on my table as I'm speaking. My colleagues from the legal division have already submitted that document. It's on my table. So if there's anyone sitting on it, it's me, where they are saying this is the criteria we think will eliminate this double notification thing. Once IACA is accepts that, they're agreeable, it goes to their council, then we are done. For us, we don't have to go anywhere. It ends with my office, because the law has already given me that power that we can do this. IACA does not have a similar provision, but their council is aware. Their council has made that directive. Their council has issued that instruction. So it's only a matter of them saying we are satisfied with this. So something just is happening. It may not be immediately now, but as everything is in law, or at least everything in life, we are working towards that. And at some point, we pray that this double notification for IACA and Quad C will end. Because just in the interest of your audience, we really need to stop to end this. as regulators, we should not be in the habit, in the game of making it very difficult for clients, making mergers very costly. No, we should be there to make your transactions smooth and easy. We should not be there to frustrate you. So ESC is 7 member states, 5 of those are in COMESA. Why should we be having double notification? So IACA and Quad C should work hard, and you should be on our throats to make sure that we resolve that.
Thanks, Willard. So first of all, I wasn't aware that we pronounced it IACA. That helps me because it's much better than the acronym that I was battling with. But that's incredibly encouraging to hear. So you're saying we got a little unlucky on the timing for Safaricom.
That's correct.
Having had no choice but to make both filings, but that we can look forward, hopefully in the relatively near future, to an elimination of a double notification if the certain criteria have been met.
Very near future, in fact, just very near future, because there's a directive from Council also at IACA that they don't want to see this double notification. So I think the boys in our courts now, the technocrats at IACA and Quad C, who actually put that in place and satisfy that council that this thing has been resolved.
That's fantastic news. Thank you for sharing that with us. I'm going to move very quickly. I know that we have actually sort of run out of our discussion time, but maybe just to touch on very, very quickly the restrictive business practices, and then we will, I see there are a few questions in the Q&A box, so we'll try and get to those. So just on restrictive business practices, there is, you mentioned it a moment ago, the suspension of regulations during member state crises. So another provision, this is a provision that's been generating some interest, right? And I'm going to throw another number at you. It's regulation number 81, which empowers the Commission to temporarily suspend certain provisions of the regulations where a member state faces a serious economic disturbance. So, you know, during COVID, we all saw how quickly crises can upend normal commercial behavior and how competition authorities around the world grappled with requests to permit conduct that would ordinarily be prohibited. So like cartel conduct, like you mentioned earlier, could a suspension under Regulation 81 extend to cartel enforcement, effectively permitting competitors to coordinate on matters like supply, distribution, or pricing in times of genuine crisis?
Good question. And I'll give my best answer that yes, the cartels can benefit from there. And from a legal point of view, that provision simply says parts of this law can be suspended during those periods of crisis. It did not say with the exception of cartels. It simply says parts of this law. And provisions on cartels are parts of that law. So I think the policy approach from the Commission should be that, in fact, cartels can benefit. The question is, which cartels should benefit from that provision? And the answer should be those cartels that are contributing to addressing the crisis that has been identified. So it will not just be any cartel. So only those that would be contributing to addressing the crisis that has been identified. As you saw during the COVID-19, it became very difficult for us and some jurisdictions because the law, so you could not allow certain companies to come together and operate together to address some of the issues that we had, especially regarding supply chains during COVID. If we had such a situation now, and there are companies that come together to attempt to address those supply chain challenges, and their behavior or their actions to give us that solutions are cartel-like, as long as the solution will benefit society, we will consider those cartels. And there'll be like what they call, I think they call it expressly like that in Europe, crisis cartels. Yeah, maybe we'll even coin them as such since we are trying to resolve a crisis at a certain time. But then the other clarification just that I wanted to make, I hear you said if there's a crisis in a member state, actually, again, we'll be very careful. We do not want the whole law or other member states to suffer just because of one country. It should be a crisis, in fact, that has a wider impact on the common market or a substantial part of it. So one country simply coming to tell us that there is a crisis in my country, then we'll have crisis every day. So it will be a crisis that has wider impact. So yes, just cartels may benefit from that also, as long as evidently, demonstrably, palpably, they contribute to resolving that problem.
Thanks, and thanks for that clarification. I had missed that nuance. Willard, you are frozen on my screen. I can hear you very well though, but
yeah, I can see I'm frozen now.
Can you still see me?
I can see you clearly, and I can see my frozen picture. So the solution to that would be me dropping off and join, but maybe that would be cumbersome. If you can hear me, it's fine.
I think we can hear you. I think we can carry on. Hopefully, it will resolve itself as we go. So just still on the business restricted business practices. So the regulations, another one under 34.4, take quite a hard line on certain vertical arrangements, right? So absolute territorial protection, restrictions on passive sales, and minimum resale price maintenance are now classified as per se prohibitions, i.e. unlawful by their very nature, with no requirement for the Commission to demonstrate any anti-competitive effect or balancing of efficiencies. For manufacturers, distributors, franchisers across the common market, this is obviously a risk, as these practices are sometimes defended on commercial grounds. What is the rationale for elevating these particular strains to per se status?
Good observation as well. Maybe a little controversial in some aspects, especially the minimum retail price maintenance, because one would say, look, we have a bigger and very odd jurisdiction, the United States of America, that recently, I think around 2007 or 2009, in fact, reversed its approach, and minimum resale price maintenance is no longer a per se offense there. I think we've had the Europeans also that have actually gone somehow in that direction, that even minimum resale price maintenance is justifiable. But it's not settled. We also have the Danish who are saying, no. For us, we will not have to conduct any detailed competition assessment. So I guess Jos also, and I'll speak to the other aspects as well. But I guess it depends with the jurisdiction, Jos, and the issues that you are attempting to address. We are a common or a member state based institution, and the member states are.
We seem to have lost Willard entirely. Sorry, everyone. Give us a moment.
Let's hold on for it. I think he's dropped off, and hopefully he will rejoin again.
Yeah, if you will just give us one moment, we'll try and get him back. In the meantime, please do feel free to carry on putting your Q&As into the Q&A box. We will try and get to them very shortly. I only have one or two more questions to put to him.
Jocelyn, I'm just wondering, while we are waiting for Willard to come back, maybe we could ask you what your thinking is around this change to per se in terms of the vertical agreements. I know I've got a view on that, but I don't know if you have one.
I mean, minimum resale price maintenance is per se prohibited here in South Africa, so it's almost the world we know. But it does seem that, as Willard was saying, many jurisdictions have moved away from it. I think that there are many instances, commercial and business reasons why you would want to at least have the opportunity to justify the conduct. And so I think, we probably share with the audience, I would have obviously preferred for it not to be. Willard has
Joyce, I'm
joined
back.
up.
I am so sorry. I don't know what happened, but at least the video is back as well.
Fantastic. Thank you. I think we're going to move on to the timing aspect of this question. And that is that we've had a question in particular. I see that the timelines in relation to investigations have been removed entirely. So investigations take a long time, which obviously places a significant burden on resources and sort of timing for the companies involved. Does the removing of the timelines for the conclusion of investigations, is it likely to shorten or lengthen the period that the Commission will take to conclude its investigations? What is the thinking behind the removing of those timelines?
Thank you, Josh. But let me quickly go back just to one issue. I will not continue talking about RPM, but the other reason, the other issue was on absolute territorial restriction. Just that one very quickly. You know that one, we were simply complying with the treaty objective, and the treaty objective is that there should be free movement of goods and services. So we did appreciate that restrictions on active sales have got these benefits, but restrictions on passive sales, we thought no. That is just a restriction on the free movement of goods and services in the common markets, and to comply with the treaty will make this one a per se offense. But active sales, no, it is still rule of reason, and will continue with the old approach. I thought I should just say, tell you that quickly as a shift in the policy. Now, in terms of timing for restrictive business practices or conduct cases, the answer is neither of that. It will not result in long periods of investigations. Neither will it shorten that. Why? Because in the first place, in fact, those time limitations never served any practical purpose. Most of the times, if not all the times, we still had to go to the provision that allowed us to extend the time period. And I think the issue here, Josh, is the nature of investigations, nature of conduct cases. Those investigations are unpredictable, and you end up getting into territories that you never even imagined when you started the investigation. I'll give you an example of CAF. We started with CAF and Lagade. But before we knew it, so many others had come in: Supersport, Bean Sport, Canal Plus, Total, so many as the investigation was going on. All these are things we did not foresee initially. So I think investigations are quite unpredictable compared to majors, and limiting them to some time may not be very helpful. But where we can do them as fast as possible, we'd be glad to do that, so that the parties are free and we also focus on other things. So to answer your question, I do not think it will have any impact on time, whether longer or shorter. The status quo would continue, because in any case, in practice, we never actually worked within those timelines. We always sought an extension.
Just, I suppose, the nature of the matter, as you say.
Yeah.
Okay, Willard, I think I've reached the end of, I have a longer list, but I am going to go to the Q&A and see if there are a couple of questions that we can address from our audience. So anonymous attendee has said, congratulations, CEO, for the good work done in rebranding CCC and to make consumer protection come out clearly in the regulations and in the name of the institution, Quad C. However, I need to hear from you, CEO, on how you intend to coordinate with continental institutions. I'm not going for this acronym, the AFCFTA and AFC. Yeah. If you have a good way to pronounce it, I'm all ears. Who have enacted continental competition and consumer protection regulations. So it's ACFA and AFCAC.
Okay. So again, the answer is simple. The same provision which talks about cooperation with other agencies, AFCFTA is one of those. The same provision that talks about having the best placed authority to deal with the issue, AFCFTA is one of those. And I've been part of the drafting of the AFCFTA competition protocol. And some of those are the issues that we also pushed in that protocol, so that there will be this demarcation of jurisdiction to avoid double notification again, or even triple notifications at AFCFTA, COMESA, and the like. So what we have done at the AFCFTA level to the anonymous person asking the question is that we've made it very clear that certain transactions will only be for national competition authorities. We've also made it very clear that some transactions will only be for regional competition authorities, and those transactions that escalate this bar, that go beyond this bar, and it will be very clear there are certain thresholds, certain criteria there that will clearly will make it very clear that this is a transaction for the continental level, and then it will go to the continental level. So in other words, to make the answer short, we have developed working mechanisms and codified them or put them in that law on how we will interact to avoid confusion in the market.
And Willard, can you give us any, so I don't know if it's maybe too early days, but any flavor for what would lead something to be a continental wide transaction? You know, is it sort of a minimum number of states? Is it particular markets? Are there particular industries that would sort of, and is the idea, sorry, just so that I'm clear, to avoid double or triple notification? So South Africa is not a member of a region, but if it's a deal that it's South Africa, no, that's not a good example.
It's
but
a good example,
a region and a continental.
Yeah.
No, I meant, sorry, of COMESA. Sorry, of course we're a member of the continent. I meant of COMESA.
No, I hear you. And yes, there's a criteria there. There are safeguards to avoid so many notifications. And one of the safeguards are thresholds. So we have, I recall, not so long ago at a meeting where these thresholds were discussed. So if they still remain the same, for notifications to be made to the continental authority, they will have to meet a combined turnover or asset value threshold of $1 billion. Okay? So if the turnover or asset value threshold is less than $1 billion, then it will not go to the AFCFTA. It may come to COMESA or ECOWAS or EAC, as the case may be, or South Africa on its own, but it will not go there. Once that threshold is met, it automatically goes there. But there are also other safeguards. Only transactions that will involve countries that belong to 2 or more regional economic communities will go there. So for argument's sake, if $1 billion is met and those countries involved only operate in COMESA, even if $1 billion is met, it may not go to the AFCFTA. Because in addition to $1 billion, there are also these other criteria. For example, at least 2 or more regional economic communities should be involved, or state parties that belong to 2 or more regional communities. There are a number of other safeguards, and Joss, if you have contact details for your audience, I think Alexia or any of my colleagues at the Quadro C may send you the current regulations that have all these different criteria. But in the interest of time, I will not go to all of them, but there are those safeguards that will avoid the confusion.
That's very, very good news. And thank you. We will get the details and make that available to anyone who is interested. I'm going to take one final question from the chat box, and then I think we will close off. The question is, and I'm not sure if it's in relation, I suspect it's in relation to our discussion on investigations relating to business practices as opposed to mergers. But it says the Quad C may consider imposing on itself a shorter investigation period where SMEs are the complainant. Oh, sorry. So it is in relation to investigation in relation to business practices. Is that something, does the nature of the complainant impact the length of the investigation?
I guess I'll have to disappoint the person posing the question, and the answer is no. It is not the nature of the complainant, SME or otherwise, but the nature of the investigation. That is what will determine the complexity of the case. That is what will determine the length of the investigation and not who is involved, unfortunately.
Understood. So one more question, sorry, that has just come, and it is a little bit controversial, but I'm going to ask it anyway, and you can choose how much detail you want to provide. But the question is, we understand based on public commentary that some African countries are very bad at cooperating with the Quad C. Which are these countries? This disclosure is important so that we as professionals and consumers can assist in bringing them to task. So I leave it to you, Willard. Sorry, I see your signal is a little shaky.
No, but I'm
again.
getting you. I'm getting you very clear. Yeah, look, and I say the absolute truth here. I'm not trying to be politically correct. To say the truth, all the countries have been very cooperative. They cooperate a lot with the Quad C. Just, I'll give you an example. Oh my God, I wanted to say the ENS transaction. The Safaricom, Vodacom transaction. We had the Kenyan officials. We invited them. We've been going to them so many times. This time we invited them. We brought them to the Quad C last week to sit down with them. We discussed. Give us first-hand information. Give us first-hand views on this transaction because we want to resolve it quickly. And they came. They came. For them to come, they are cooperating. They did not say, in fact, Safaricom on the continent of Africa is largely in Kenya. No. So we are not even going to come there to Quad C in Malawi. We are not going to do it ourselves in Kenya. No, they came, they complied and obliged with our request. So there's been very good levels of cooperation for all the countries. Egypt was mentioned. And I want to put it on record that even Egypt have been very cooperative generally. The issues that we are having on these measures, number one, I may call them teething problems because Egypt has recently had the major control provision. So there could be those teething problems. And then number two, just that we have this issue, which is not official, by the way, to the Quad C. Because to the Quad C, the position we have officially from Egypt is different. But to the extent that there is an element of truth to that, I think it cannot just throw in disarray everything else on competition enforcement, the cooperation that we've had with the Egyptian Competition Authority. I think when the CAF case that I spoke about on the investigation front, the Egyptian Competition Authority, we worked with them very closely. In fact, they brought that matter to the Quad C. So all countries generally, they are cooperating. I'm not being politically correct. That's a position. Where there may be an issue, I would call it a teething issue, and I can assure you that we will sit down. And just one final comment. I know there's this saying that African countries are not very good at complying with laws. Yes, it's true. Sometimes we've had disappointing observations in some instances. But from the competition point of view, especially COMESA countries, I think they should be given kudos. They have really complied and cooperated to levels, in fact, that were not anticipated. And we should commend them for that.
Thanks, Willard. And I must say, from our side, and I'm also not being politically correct, but our interactions with the COMESA Authority have always been incredibly positive. You and your team have always been accessible and helping us to manage and navigate these issues. So I would support your submission in that regard.
Thank you.
So closing from me, we have covered a lot of ground today. On behalf of everyone joining us, I do want to thank you for the generosity that you've shown us, not just of your time, but in your candor, in just openly answering all of these questions. And I know that I've put some controversial questions to you. So I'm really grateful for that. I think these regulations represent a bold and fairly ambitious new chapter for Quad C. And we're excited for you. As we look ahead to the rest of 26 and beyond, what message would you like to leave with businesses and advisors across the region? And I say across the region, but in fact, on this call, we have people not just from the continent, but all over the globe. Your message can be broader, and maybe just how can stakeholders best partner with the Commission to ensure that the implementation and rollout of these regulations is smooth, predictable, and ultimately serves the goals of regional integration and consumer welfare.
Yeah, something like short of what to say really, but look, I think I have 2 or 3. The first thing, Joss, is that he who, and he means the she's, so general use of the word he or she, they know it all, they will never grow. Okay, are you still getting me, Joss? I think your video was frozen. He or she who think or who believes that they know it all will never grow. That's the first point I'm giving to the world today. The Quad C should not pretend that they are the masters of this book. The Quad C should also learn and be responsive to what business and the stakeholders are saying. That's the only way we are going to ensure that we implement this law effectively, efficiently. Number 2, so we are there to learn from you as well. Please join us to make sure that we come up with working policies, working guidelines, working rules that will help us save the market better. Number 2, the Quad C is not in the business of finding fault with businesses. It's not in the business of Tom and Jerry, cat and mouse. No. That's why you see us issuing practice notes every now and then, even before we received any application, or maybe by that time we only had one from ENS on Safaricom, I'm not so sure. We already started issuing practice notes, that practice note 1 of 2026, to address some of the questions and guide the parties so that they don't find themselves on the wrong side of the law. We are not in the business of Tom and Jerry, cat and mouse. We are in the business of being so transparent so that the parties and the businesses already are aware of what we are looking at. And then number 3, the last one, Joss, this that you are doing even today. Let us have so many of such engagements. The law has been developed. I feel bad when regulators, and I've seen this before, but when regulators begin to think they are the alphas and omegas of the implementation of laws, no, they are not. We are not. We are simply administrators of this law. You, the users of this law, are the ones who should actually guide us, unless the guidance is not acceptable, but guide us on what you think is the best way of addressing an issue. So let us continue with such engagements, Joss. Again, what I said at the beginning, lawyers, both in South Africa, common market, but also beyond, have really helped the Quad C in their submissions. We changed from 0 notification to meaningful thresholds because lawyers argued and gave us examples. We want to see this again. We will not tire. You will not be frustrating us. You will not be disappointing us. You will be helping us. That would be my last message. Thank you so much, Joss.
Thank you, Willard, and thank you once again for this discussion. It's been hugely insightful for me, no doubt for our audience. I really, really appreciate your time. I absolutely think we should do a part 2. There were a number of other questions, particularly on the digital market stuff that we did not get to. No doubt there are many, many others. So I look forward to our continuing engagements, and best of luck for the new chapter. Thank you for joining.
Thank you very much. Thank you so very much. We need those good wishes, and we hope we save the market to the best of our ability. Thank you.
Thanks so much. Thanks, everyone.
Bye-bye.
Bye-bye.